arose that a party said, me, I don't want that mzee to be there or that other one, invariably, and this is communal justice, that person would pull out and get a mzee, another mzee, that everybody feels comfortable with. So that, my Lord, and I've appeared with you, I respect all of you absolutely. The petitioners are saying the circumstances of this matter is that we are unable to enjoy that confidence. My Lord, when the petitioners were speaking about what they said they feel, like is a three-judge bench, one in which they expect fair and square justice. That was the terminology in the case of Githunguri that we have attached on our submissions. That from the word go, a party appearing before the judges should be able to feel that we have a reasonable chances of success between those judges, but more importantly, that none of the judges is connected to the cause, one, to the cause, or to the individual in which you are in dispute with. My Lord, why is that important? That, my Lord, is important because since Saturday of this week, in fact up to yesterday, but the petitioner says they have been treated to a situation, and a lot of those information people have sent it to my phones because they have seen me on televisions, where we have such a scenario that repeatedly they keep saying we are going to have what is it called? We are going to have a swearing in as soon as these three judges lift those particular orders. My Lord, that cannot create confidence, because assuming it is not this case, every party, and we have very many cases here, if somebody, you are drinking him in a bar, says, no, you are going to lose that case before the persons we are appearing before. That, my Lord, is a party. Parties are not lawyers, are not supposed to be sophisticated. That party will be left certainly with a huge, huge problem as to whether actual justice is possible. And it might actually be, my Lord, that whenever else is dealt, the petitioners will win this case. As we expect, we shall win if the petition is heard. My Lord, if that is the case, and that may actually be the case before you, but, my Lord, the scenario that is bad and that is prevented by the law is a scenario where the parties lose. Because they will say, well, Ahmed Nasir told us, Oscar Sudi told us, Kamket told us, and all these individuals who are saying it was called drama. We are here for entertainment. My Lord, if judges are supposed to be treated to entertainment, and those judges are supposed to stop that entertainment, my Lord, there is a problem on the face of it. There is a notice of appeal that we have filed, and it is part of the supplementary affidavit. In this notice of appeal, your lordships, we have pointed the issue, and we have said one of the other issues of concern is that the judgment of this court that dealt with these other issues, that judgment, the contents of that, amounted to preempting and answering the application that I'm arguing before the court. Because those issues we are submitting did not come from the respondents, but these applications having been filed, we are arguing these applications. After, in a previous ruling of yesterday, we have effectively been responded by the court itself. The petitioner says that they are absolutely uncomfortable with that, and they cannot be able to say that if we have reached a situation whereby judges are answering our case in advance, it is absolutely bad and beyond repair. My Lord, the second last issue that I want to say is this. The issues, my Lord, is, and we expressed that concern yesterday, we were not sure whether we would even file a notice of appeal as counsel. But you are told you cannot file this one because it is the issue, as far as we are concerned, we were not treated fairly. We were accused, we are playing to the gallery, as a result of the accusations and indictment that we are playing to the gallery. What effectively ended up being glossed over is the question of our own submissions. And, my Lord, the basis, and therefore the accusation, and we are saying we were not treated in a temperate and judicious manner. The petitioners and their advocates. Then, my Lord, we go to the deciding for purposes of yesterday, the core issue. My Lord, the core issue in our petitions, a number of them when it comes, would be the question, does the IEBC have the power to have authorized the president to say that Kibe, I'm saying it is in our petition. I'm saying one of the issues that will be coming in for determination would...
I think it's important to just help my learned friend. We are not arguing the substantive application. It's a recusal. Let him stick to the issues.
Let him hear the issue and the answers. My
But
Lord,
just do the right thing.
My Lord, the point I was making is this. One of the questions, I want to tie it with the 165. And the question is this. The question that would be arising is whether the IEBC without commissioners could have declared Honorable Kindiki to be suitable for this nomination in the letter they did to the president. My Lord, that particular issue is significant because the petitioners are saying that this court, having effectively read Article 165(4) in a manner that amounts to amendment of Article 165(4), they perceive the real danger that when a more important question arises, the same logic would be applied against them. And they are saying, this being a very serious legal issues, the bench cannot be said that for purposes of the issues actually in contention, that people can be oblivious of such an issue. I need like 2 or 3 minutes. My Lord, having said that, therefore, it is our submissions. And as our Honorable Mwita has said, nobody extracts any joy to raise this kind of an applications because judges are legal colleagues. But, my Lord, the point that we also want to add for purposes of this application, this is